everyone. My name is Donald Granchty. I'm the chairman of the New York City Loft Board, and I would like to welcome everyone to the April 24th, 2014 public meeting. First, take a moment to share the minutes with the board. And are there any corrections, comments with the minutes from last month's meeting? Seeing none, I'd like to ask for a motion to accept the minutes. Mr. Fowler, thank you. In a second. Ms. Bolton-Vera, thank you.
Ms. Rivera.
Ms. Rivera, can you poll one?
Mr. Barrett?
Yes.
Mr. Mayor? Chief Sparafora?
Yes.
Chairman Chesky?
Yes.
Mr. Delaney?
Yes.
Ms. Bolton-Rivera?
Yes.
Mr. Patton?
Yes.
Mr. Schechter?
Yes.
Ms. Shelton?
Yes. Oh, Mr. Ready to abstain, I wasn't here at that time. That's right. Oh.
Support of it.
Okay, you can announce the vote, please.
Sure. 7 in favor, 1 abstain, and I believe Mr. Barrett said 1 rescue.
No, it's 7 and 2 abstain.
2 abstain, okay.
All right. Executive Director's report. Ms. Alexander, please give your report.
Good afternoon, everyone. I just want to say welcome to Irma Rivera, who is our new board secretary and is, I have to say, is fairly scared to death right now. And I've assured her that everybody will be more than kind about her mispronouncing the names, although we are working on it, okay? And as somebody who mispronounces names all the time, you know, I do have an affinity and I feel for this. So to get to the report, we have 332 buildings currently registered with the Loft Board. The rest of the statistics we will be giving you in full next month, and as you have asked me to do, I will send you a sheet with all of the statistics prior to the meeting so you can look at it and add it up, and if you find there's a mistake, could you email me if I made a math mistake? Thank you. We are going to be moving, as I told you before, and it is a go now. We have been working very hard in preparing for this move, and it is an interesting process. To give you more of information about what's going on, when we came to the Department of Buildings, we were placed in with the Borough Commissioner's staff. And it was very kind of them to offer us this space. It made them very crowded. It made us very crowded. We used their public window. They've been wonderful about helping us with that. It's very noisy there. That's the nature of what they do. They have windows and they have public, and it's very noisy. And that's been the bad part, was the noisy. The great part was that we had access to all kinds of people in the borough's office who taught us so many things about the process at DOB. And we are really grateful to them for all of the information that they've shared with us in helping us know what the procedures are. And that has helped us help the owners and the tenants with all of their filings. The biggest part about the move is, you know, that we have a lot of paper files. And when we moved from 100 Gold Street, the files were moved with us. They were initially placed on the 3rd floor in an empty room, but that room had been promised to all of the DOB staff as a lunchroom. So eventually our files were moved downstairs, and they have been there ever since. So now we are going to be moving them upstairs because we're going to have a file room. It's going to be a little bit smaller than what we possibly might need, but we're culling out a lot of the files that we are not going to need on a daily basis. And we've been told that we will have a 24-hour turnaround when we need files, that they will come back to us in 24 hours. So mostly what we're going to make sure we keep with us are all the files for the new buildings. And then we're going to make a judgment call about some of the other buildings. Most of the narrative statement, old narrative statement information will go into archives. All of the buildings that have left our jurisdiction but have stayed with us, they're going to archives. And so that's what we're doing right now. And again, the staff is working so hard, spearheaded by Irma and by Althea Bender, our attorney, and they're working overtime to get this done. Once that's all done, we're going to bring the files upstairs, but then we still have to work on moving all of our staff, all of our other materials, all of the computers and all that stuff, which DOB will do for us. And so this is going to be a little bit of a mess for the next month and a half. So if we are not giving you as many cases as we would like, I think that's probably the reason. So that's a little update on our move. Yes, Mr. Delaney.
Or is there, I guess, an option to take some of those older files, not clearly the plans and stuff, but like 8.5, 11 paper and scan them?
We had discussed that, and that would have been the optimal thing to do. As a matter of fact, we were hoping, and certainly Commissioner Lamandry, former Commissioner Lamandry, wanted to do that. But every time we tried to get the funding for that, we were not able to get it. It would be a very expensive. It would have been very expensive to do all of our files. To do the files that are going, I'm not sure how expensive it would be, but it seems that we can't get the funding at the time to do that. Again, what we're sending to archives are buildings that are no longer in our jurisdiction.
Just a point of information, the American Library Association puts all of their files on microfiche. And the reason why they do that is that they're claiming that all new digital technology will become passé in time, and they're afraid that it's all going to get lost, like floppy disks. They're unusable. So for whatever it's worth, it may be better for the while to sort of keep them as hard copies.
Yes. Okay, so one of the things that was of particular interest to all of us at the last meeting was what was going to happen because of the statute of limitations. Now, I know that there are many advocates in the Loft community that are going to be working to have that statute of limitations lifted or delayed, and that's something that's ongoing. Right now, what we are doing is we're really going application by application in formulating what we're going to do. So I can tell you that we have received applications, amended applications from tenants who wish to clarify, they're amending to clarify a unit that was mentioned in their original application, and now they're giving it a name, they're giving the tenants a name, and we have accepted those applications. We have also gotten amended applications for tenants who have wanted to amend and add new units to their application. Now, we are not at this stage going to make any kind of legal evaluation of the application. I think that they all deserve their due process. So we are forwarding them to Oath, and Oath will make their determination of whether they are acceptable or whether they're time barred. They will forward and then do whatever they do, then they will forward it to us, and we will make our determination, and that will be something that the board will do along with the staff. We have not yet, I don't think, received an application for a building that's never been, that's never had an application before. I will say that those we will reject. We will not take the money for those applications. We will just say no. But so far, that's the scenario that we've seen thus far. To go and start trying to figure out hypothetically what we would do if is you know, so daunting that we're not going to do it. We're just going to wait and see what occurs. So that is my report. If you have any questions, comments? Mr. Schechter.
So, and I appreciate you giving some of the update regarding those amended applications. Did the law department provide any kind of guidance or recommendations regarding those? Because I know you were in contact with them.
We went through these scenarios, and they agreed with that. The remaining scenarios that we can think of are really things that the board and the new commissioner is going to have to determine. It's really very much policy driven as well as legally driven. So we're again going to wait and see what happens, and also see what the new commissioner will want to do. Anything else? No. Okay.
Thank you, Ms. Alexander. We'll turn to the cases. Our first case is an appeal of an administrative determination. Ms. Cruz is not in today, so Ms. Alexander, will you please introduce this case?
Certainly. This is 26 Bond Street Management, LLC. The address is 26 Bond Street, and it is AD 0069. Now, please remember that this was an administrative determination made by me, so this is from Martha, and so I'm reading what she prepared for you. On November 13th, 2013, the owner filed an application for extensions of the code compliance deadlines for obtaining a permit, 7B compliance, and a certificate of occupancy. On February 14th, 2014, the executive director of the Loft Board issued an administrative determination denying the extension application because it was untimely, because it was filed after the code compliance deadlines had passed. The owner did not qualify as a new owner, and even if the owner had qualified as a new owner, the application was still untimely. In this administrative appeal, the owner argued that the determination was arbitrary and capricious in that the corporate entity that owns the building is a new owner, and the executive director had the discretion to consider excusable delay. Pursuant to 29 Rules of the City of New York, Section 201B1, the Loft Board may not grant any application seeking an extension for time for a past code compliance deadline unless the owner qualifies as a new owner as defined by the Loft Board rules. The compliance deadlines for this building are September 1st, 1999 for an alteration application, March 1st, 2000 for a permit, June 1st, 2012 for 7B compliance, and July 2nd, 2012 for a certificate of occupancy. The owner filed the extension application on November 13th, 2013, long after the expiration of the code compliance deadlines. The owner argues that it may file extension applications after the deadline passed because it is a new owner. However, the record does not support this position. The Loft Board rules define new owner as an unrelated entity or unrelated natural person to whom ownership interest is conveyed by a bona fide business purpose, for a bona fide business purpose. Excuse me. Here, the new corporate owner is not an unrelated entity as required by the rule. The property transfer report filed with the Department of Finance shows that the transfer of the building occurred between related companies. The owner presented no evidence to demonstrate the 26 Bond Street Management LLC is unrelated to the former owner. It is also noteworthy that the former owner is the mother of the president of the current owner. Even if the owner were to be considered a new owner, pursuant to Section 201B, the extension application would still be untimely. Loft Board Rule 201B1 specifically states that where title to the IMD was conveyed to a new owner, that owner may file an application for extension of the most recently passed deadline within 90 days of the acquisition of title. The owner did not file the application within 90 days from acquiring title as required by the rule. Owner contends that the executive director had the discretion to toll this statute of limitations. However, this is untrue. Section 201B1 specifically provides that an application for an extension shall not be filed after the deadline for which an extension is sought has passed. The executive director has no discretion. The staff recommends that this administrative appeal be denied.
Do any of the members have questions or comments? Yes, Mr. Blank.
Just one comment. The backup material for this case, which was very interesting, was scanned and sent to us upside down. It would it would help if somebody could check for that, because it makes it. Then you have to print it out.
No, I called Martha. She told me that you could reverse it by going up.
Well, there's a trick
Yeah.
in PDFs.
Yeah, you go up to the
Okay, I
You
didn't waste my whole technique to find
90
it
degrees and then 90 degrees again, so it's...
page by page.
No, the whole
No,
document.
you do the whole document.
Okay.
So
All right,
it's-
fine, good.
I'm glad to learn that. It's a big relief.
The other question I had is, for those of you who may not be familiar, I think this building has been before the board with various cases between the former owner and now the current owner for longer than probably any of you have been on the Loft board. And I also note the rather crisp tone in the opinion as it's written. And I know we're kind of theoretically waiting to discuss policy issues until there's a new commissioner appointed, but this, if there's ever a building that cried out for enforcement measures, this building has been in our face since before you were the executive director. I mean, it's ridiculous. This is one of the worst foot dragger, bogus excuse makers that we've dealt with over the years. And is there some way we can come up with you know, we now don't really have an enforcement unit per se, and to the extent that it allows a building like this to come in with this set of arguments is...
At the moment, they are 7B compliant. They've reached every milestone now, except for the C of O. And hopefully we will be able to coerce the parties to go to the final step. But you're absolutely right, they are.
Okay, all right.
I don't understand why this came back to us after it had been housing. This appeal was denied there.
No, that's a different case.
Oh, excuse me.
That's a different case.
I'm sorry. All right. I know that building. On the outside, it doesn't even look like anybody's living there. But apparently there are. And it's just right around the corner from me. And it's on this block, but there's been this tremendous new development. A bunch of new apartment houses, got to be a rather fancy block, and this is this one sort of not terribly cared for one building on this block. And we really should move on this thing as best we can, because it's, as I said, I remember this coming up. Yeah.
I can tell you that in the recent several years after Ms. Chamby died, this building was in litigation between the brother and the sister. So there was, it was not sure who the actual owner of the building was until it was finally settled.
Other questions, comments? Is there a motion to accept the case? Mr. Mayor, thank you. And a second, please. Mr. Barowitz. Mr. Rivera, please poll the board members.
Mr. Barrett,
Yes.
Mr. Mayers,
Yes.
Chief Sparathoro,
Yes?
Chairman Chanty,
Yes.
Mr. Delaney,
Yes.
Ms. Bolden Rivera, Mr. Patton,
Yes.
Mr. Schechter,
Yes.
Ms. Shelton. Yes. 9 votes in favor.
Thank you, Ms. Rivera. Next case is a reconsideration case. Ms. Alexander, could you please introduce this one?
Certainly. This is Jean-Luc Fever, Tessa Grundon, and Mark Vieder, 59 Crosby Street, R0336. This reconsideration application filed by the tenants of Units 2 and 5 in 59 Crosby Street, New York, New York, seeks review of Loft Board Order Number 4227, issued on January 16, 2014, which denied tenants' claim of coverage, re-regulation of rent, and protected occupant status pursuant to Multiple Dwelling Law 2815. On February 5, 2014, the Loft Board mailed Order 4227 to the parties. On March 7, 2014, exactly 30 calendar days from the mailing date of the order, tenants filed a reconsideration application requesting review of the order. However, the application filing did not include proof of service of the reconsideration application on the affected parties. On March 21, 2014, tenants' attorneys resubmitted the application along with a copy of the delivery receipts indicating service of the application by Federal Express. The Loft Board rules contain specific filing requirements for reconsideration applications. To be considered complete, Section 107B1(ic) requires the aggrieved party file proof of service of the reconsideration application on all affected parties within the 30 days after the mailing date of the underlying order. Service of a reconsideration application must be in accordance with the provisions of 29 RCNY Section 106B1, which defines proof of service as a stamped copy of a certificate of mailing. Here, tenants filed their application on the last date of the statute of limitations, but failed to include any proof of service. Therefore, the filing was incomplete. Tenants attempted to correct their application by filing again on March 21, 2014, 2 weeks after the expiration date of the statute of limitations, together with the proof of service. However, even if the proof of service had been proper, which it was not, the Loft Board may not consider the refiled application. In matter of Kenzen Institute Limited, the Loft Board dismissed the owner's application for reconsideration based on untimeliness when the owner wrote a letter to the executive director requesting reconsideration of an order 13 days before the statute of limitations expired, but failed to comply with the application filing requirements before the statute of limitations expired. Excuse me. In that case, the Loft Board held that 107B contained no provision allowing extensions of the 30-day deadline to supplement an incomplete application or correct filing defects, finding that the staff had no authority to contravene the plain language of the rule. By waiting until the last day of the statute of limitations period, the tenants left themselves no time to correct the filing errors. Because the application filing with proof of service was filed after the statute of limitations, the staff recommends dismissing the reconsideration application as untimely. Excuse me. Are there any questions or comments?
This way.
Yeah. Did the owner, did the attorneys for the owner object to the application being untimely?
No, they did not.
But they did indeed file an answer.
They did file an answer.
And we do not accept service by FedEx. I realize this was after the fact, but
Right.
Is that a common practice in courts not to accept?
It is specifically stated in our rule what the appropriate service is. We could have included Federal Express. We didn't, and we didn't include the certified mail, and we did that specifically because we found that people who had to sign for things didn't sign for them and therefore didn't receive the notice. So that it was better to get them to have it come through regular mail. And that's what we did. And that was the theory behind it.
Obviously, I'm troubled by this case. I voted against our decision in it initially. And clearly the attorney for the applicants went to a great deal of trouble preparing this application for reconsideration. So it's unfortunate to see it knocked out on a technicality if the application were late, that would clearly be outside the boundaries, but to my recollection, this is the first time we've seen something declared to be untimely for the lack of the proof of mailing to the other party. Although the other party seems to have answered, so it doesn't appear that they were harmed. So this really seems to hang on an administrative interpretation that's very slender.
The rule is what it is, and the case that we cited was very specific in that the law in that case, the executive director, because the woman sent a letter, and then when we told her you can't, the letter is unacceptable, by that time the statute of limitations had run. So she then filed her application, and the executive director had said, yes, we'll extend the time you can file a real application. And the board slapped the executive director back and stepped back and said, no, you do not have the discretion to do that. This happened again in another case where an architect wrote us a letter requesting that we extended the compliance deadlines. We didn't really focus on it, and by the time we realized that it was there, the time period had passed. And we again found it to be untimely, and it was dismissed. So yes, it seems like, you know, it's a technicality, and that's exactly what it is. It's a technicality. This does not leave her without recourse.
Yes, Mr. Mayor.
Look, this is, you know, whatever equities exist, this is a motion for reconsideration, which by its nature is fairly extraordinary. And while we might be sympathetic to a technical problem, reconsideration is not as of right, and I have no sympathy. I think we should move on.
I would just note that neither of the cases that you cited exactly parallels this. In this case, it wasn't somebody who submitted a letter and said, and the executive director said, make it an application. Here, a real application was submitted, and it was simply this certificate of mailing that was absent.
Noted.
Other questions, comments? No? Is there a motion to accept the case? Mr. Mayor, in a second. Mr. Fogg, thank you. Ms. Rivera, please pull the board.
Mr. Bowers,
Abstain.
Mr. Mayor,
Yes.
Chief Sparrow,
Yes.
Chairman Shanti,
Yes.
Mr. Delaney,
No.
Ms. Golden Rivera,
Yes.
Mr. Foggins,
Yes.
Mr. Schachter,
Yes.
Ms. Sheldon,
Yes.
seven in favor, one against, and one abstain.
Thank you, Mr. Rivera. And our summary case calendar, there are 4 summary cases. These cases are voted on as a group. And Ms. Alexander, please announce and introduce the cases to the board.
All right, thank you. 5565 South 11th Street tenants, 5565 South 11th Street, Brooklyn, TR0829. Catherine Clark, W. Douglas Ramine, Willie Worth, and Petra Hansen, 46 Old Fulton Street, TR0844. Weena Lynn and Greg Laborde, 151 Kent Avenue, Brooklyn, TR0865. And Christian Calabro, John Wigder, Larissa Vargas, Miles Michael, and Sarah Tompkins, 178 Walworth Street, Brooklyn, TR0898. I will remind you that the first case, 5565 South 11th Street, is the case that was tabled from last month. Thus, I'll ask if does anybody have any questions or comments about these cases?
Same question as last month. This seems to, and it's with regard to the third case, 5565 South 11th Street, where it's the same questions I asked last month in terms of how do you distinguish this as being acceptable as a solution, which seems to me to be setting up a parallel universe outside the law firm.
Okay, it was something that we sort of said last time, which I'll restate again. When we rejected 2 settlements before, there was clear public policy issues with respect to the fact that we were now on notice that these tenants were going to be living in and occupying residentially 2 buildings where we knew that the owner had no intent or obligation, nor could he, without a variance from the Board of Standards and Appeal, could he legalize the buildings for residential use. That was clearly a public policy issue, not only for the board, but in particular for the commissioner of DOB, who was also the chairman at the time. And so we rejected them. One of those cases is now being appealed in Article 78, so more than that I'm not going to say about it. However, with regard to this case and this line of cases, there is clearly no public policy issue with regard to an owner who is in a residentially zoned area agreeing with his tenants that he will and will be obligated in writing to legalize the building, has filed an alteration type 1, has pulled his permit to do the work, has specified in the settlement agreement how he's going to go forward with the work. There's no way, there's no reason for us to say that we would not accept that. It would not be, it would, if we were to do that and somebody were to bring in Article 78, we would lose. There's no legitimate legal reason to reject it. Further than that, with regard to the concerns about what's going to happen with these buildings, Mr. Ranchi and I were discussing that this morning.
So in terms of enforcement, when we look at what the Loft Board is supposed to do, we find that there's no real way to relay back to the Department of Buildings in a meaningful fashion that because they're no longer or not in the jurisdiction of the board, that the staff of the board needs to make the Department of Buildings aware. Now, there is already an indication in the Department of Buildings internal system of tracking buildings that has a designation for potential Loft Board registration or coverage or not in manufacturing districts. So if there was a change in status from yes to no, for example, the Department of Buildings would already be aware of the fact that that building is not coming into the jurisdiction or leaving the jurisdiction of the Loft Board, and would be able to enact any sort of enforcement against that building that it so choose to do at that time anyway. Now, I can take back to the Deputy Commissioner for Enforcement at the Department of Buildings if that is enough for him to act. And I would assume that he would say yes, but certainly if the board would like him to do that, I can do that.
Well, my particular concern, as we seem to be seeing this new avenue of an approach being kind of cobbled together, what if there's an agreement in place and the timetable for the owner to perform code compliance runs to 5 years? What if there's an agreement between the parties that the code compliance table will run to 15 years? I really believe that this is opening a Pandora's box, that you either qualify for being an IMD or you don't. And if you do, for both sides to get together and say, you know what, it'd be easier if we did this in a different route. I don't see the logic of that. I don't see the wisdom of it.
Yes, Mr. Mayor.
Let's relate Chuck's concern to the procedure. Is it your view that once someone files, they're stuck? Or are you suggesting that if no one ever files, we have some broad jurisdiction to question consensual relations, consensual real estate relations between tenants and landlords.
I'm afraid I don't understand your
Oh, I'm
question.
trying to figure out what's irking you. Is what's irking you that there was an application that a tenant's trying to withdraw, but supposing there were no application? Nothing was before us, and the landlord got together with tenants, and rather than agreeing to apply for coverage, they worked out a deal. Would that irk you?
It would irk me in the abstract, but that's not the case at hand.
But why is the mere fact of an application trigger this broad jurisdiction? You still have, the Department of Buildings still has whatever remedies it has for unlawful occupancy, and if someone hasn't filed for coverage, at least in theory, they could go after the owners, right? It's not an IMD. I mean, I think what we don't need is a self-created broadening of our jurisdiction, except in extreme cases as the one that Lonnie had indicated.
Mr. Fogg?
So I'm somewhat persuaded by that. Where I was thinking, perhaps from a much more basic standpoint, was we're now on notice of this illegal and you know, theoretically unsafe situation. And we're essentially allowing it to happen by doing.
Where do you get allowed? What is allow is not the appropriate verb. Allow means you have a legal right to stop it. It's assuming a conclusion.
Well, don't we know? Because you're occupying a building without being entitled to that's legal. That is there. The basis for exploring or acting on is there. It is an illegal occupancy. The question is, do we have to wait until someone files, or do we have some other mechanism to start, right?
One of the comments that I made after I mentioned is, what's the relationship between the Loft Board and the Department of Buildings in a situation like this, right? Because do we notify them on record? What's the relationship?
Well, we are now part of the Department of Buildings. Do we send them addresses and go up and talk to them about it? Only on very, very rare occasions. When something comes into me that demonstrates that there is an absolute, no questions, safety issue, I will take that and I will bring it to the chairman. I will bring it to the Deputy Commissioner for Enforcement. Other than that, I won't do that. I try not to bring many of the complaints for buildings that are in our jurisdiction to DOB because I don't want the buildings vacated. But those are the ones that are in our jurisdiction. Without knowing if there's a safety issue involved, and we don't, all we know is that it's illegally occupied.
Well, allow me to say this. So other city agencies have the ability to refer a case to the Department of Buildings for enforcement. The fire department, there is a formal protocol for referral from one agency to another. In the same way, in a very similar way, the Loft Board does that with those buildings that are either being considered for registration or coverage by changing the system that we use to show whether or not a building can be lawfully occupied by residential tenants when it's not in a residential zone. So that already happens without a member of the staff of the Loft Board specifically calling up to say this building has come in or out of jurisdiction. Yes, Ms. Schachter.
I think that I'm not seeking to expand either our responsibilities or our purview, but it seems to me that if we've been on notice that there's an illegal occupation and the building is not going to participate in our program, then we should do a formal referral to the Department of Buildings saying, FYI, this, there's an illegal occupation. It is not in our program, and then it's up to the Department of Buildings to make a decision on what to do with that information. But so I'm not trying to add to our Loft But I don't think there should be any ambiguity, and I don't think it's the, I don't think the executive director should be put in a position where she has to make an evaluation as to the safety risks involved,
When,
I agree with the last part of your statement. Prior to the 210 local, all of the buildings were big. And there are many buildings in Brooklyn that are still under the radar, where there are more than 3 people not related by blood and marriage that are in floor spaces. Now, on the other hand, when the time ago mayor tried to evict the law tenants in Brooklyn, the judge said no. They were all illegal at that point. The judge said no. And probably this would happen again if we decided to enforce this building and they went into the courts and the judge says we're not going to allow the city to throw people out of buildings, whether it's legal or not. This is the whole sort of catch here about the Loft law and about trying to expand it or one thing or another. It just gets awfully confusing. But I agree with you that it shouldn't be up to our executive director to make the determination whether the building is safe for occupancy or not, and whatever that means.
But I think it goes much farther than that. And, Matt, to get back to your question, when a party brings a case before oath, who is our designated hearing agency, for them to broker an arrangement of this kind, the question should be, are you covered or aren't you covered, not is there some flavor of kind of coverage that we can cobble together that will suit your needs? Listen to this, number 6 on page 2 of the STIP. The applicants shall each have such rights and obligations with respect to their respective units at addresses as if they were rent-stabilized tenants, except as follows. Landlord shall not assert rights to luxury deed control, owner's use, nor seek to demolish the building. Is that going to follow to the next one? The building need not be registered with DHCR. Need not be registered with DHCR. In the event of a dispute between the parties concerning rights and obligations, the parties consent to the jurisdiction of civil court or Supreme Court, County of Kings. Last sentence. In the event that building services required under this agreement are not maintained by landlord, no need. Landlord agrees that the tenants have the right to bring an HP case in housing court, Kings County. We're just creating we have old law tenements still. Why are we creating a new building, a new residential building?
Well, but I suppose we could agree with the policy you're articulating, but the question is whether we have the legal right to proceed the way you want. Lonnie, do you know the case that you mentioned where there's a challenge to the public policy case you mentioned where we refuse to accept the stipulation? Is the legal challenge in that case of our authority to take the actions that we took? Do you know?
yes.
Yes? Mm-hmm. So perhaps what we need to do is to wait for some guidance from the judiciary as to whether we have this right. That would frame our inquiry. And I don't know where that case is procedurally, but might that be an inquiry?
Where would we go with this? What judiciary? Where would we go to this?
Well, right now, it's in state Supreme Court.
It is.
Yes.
But Matt, I don't think that's really going to give us guidance, because if that's the case, I believe it is, the provisions there were so beyond the pale that a decision slapping that down would not necessarily translate into...
No, but if it is, the opposite. If the court found in a situation as extreme as that we didn't have authority, that would be dispositive. Right?
Again, the Department of Buildings has the information about what buildings are in our jurisdiction, what buildings have applied for our coverage, and what buildings have applied and are no longer, and they have not, they're gone from the, what we call application pending, but they're not loft law, yes. They have that in their system. They're aware of those things.
That would be notification from the board. To change the statute would be notification.
How many buildings do they get? The Department of Buildings have in their system that just kind of goes through the system? So for us to say, a lot. So for us to just say that we don't have to give them a referral because it's automatically logged in, I think is.
No, well, on the internal system that the enforcement units use to track buildings, there would only be a few hundred that the loft board would be entering pending status or not. So the change in that status would be pretty readily available for everyone to see as soon as the status changes.
Is there someone that's dedicated to the loft board that reviews this information?
No, there currently is not.
Can I just say a few things? The first one is that while the loft board can give the information hypothetically, theoretically, to, let's say, the deputy commissioner of enforcement, the loft board cannot tell the deputy commissioner of enforcement what to do with that information. The deputy commissioner is going to have to make the determination himself. Now, that would also speak to what the commissioner of the Department of Buildings would determine should be done. And until we have a commissioner for the Department of Buildings, I suggest that we consider tabling this discussion.
And I'm fine with tabling this discussion. I'd just like to add one piece. The loft board has a board that should do the responsible thing that they've come up with. Now, the decision to take that information or not, I understand is not within our purview, but I do think that we could decide we have a responsibility to do more and do it.
That's right.
Yes,
I mean, that's like, I don't know what the mayor may decide about law. I don't know what the new commissioner may decide. I mean, none of these are pertinent. The only question is what we do with the information when a building that we know is illegally occupied and is not going to participate in our program, and whether we provide a formal notice to enforcement. Whether they make it a priority or not, I agree. It's entirely beyond our scope. As far as I'm concerned, it's a hot potato, and I don't want us to end up in the expression sitting on it.
It was also a problem that we anticipated during the time when the law first was expanded. And I met with many tenants who were very concerned that they would file an application for coverage, and they would lose for some reason or another, and then they would wind up losing their apartments. When we have a situation where it's in a zone where it can't be legalized, well, I'm not particularly given to that argument, but certainly in areas where we've seen demonstrations of the owners going to do all of the legalization work, I'm less concerned.
Let me just add that
I'm just as concerned as there's an illegal occupation.
I know, but see, on the other hand, I would just not vote to have somebody eventually removed from the building. I just couldn't in my own conscience. I just can't do that.
It's a huge liability for the city to know that there's illegal occupancy, because if something happens, they're gonna say you knew about it and you didn't do anything about it.
Well, that's exactly what happened for 25, 30 years, as people began to move into Brooklyn Lofts. They were all illegal, and they had been illegal for years. And at one time, Giuliani wanted to kick them out, and the judge said no, right? They're not going to throw people out onto the street. And I just can't see doing that. And since I know some of these buildings that are just, they don't conform in one way or another, but there are people that are living there. I mean, how could you say, forget it? And it's, my bottom line on this is the fact that loft tenants add to the culture and the welfare of the city of New York. And if you begin to throw them out, we begin to lose, some real good quality of the city.
Yes, Chief Spatler.
But there's a difference between illegal and public safety, all right? So, I mean, in the fire service, there's a big difference between them not having a piece of paper saying that this is legal or not, and them not having a secondary means of egress to get out in case of a fire or emergency. So, big difference between the two.
Yeah, I think the chief is exactly right. First of all, there is, for whatever degree you want to call it formal, there is a formal notification in the status change from pending to no. So the board does let the Department of Building know that there's a change of status. So that's the first thing. And the second thing is, even with that information, should the Department of Buildings follow up in a timely fashion and do an inspection of that building, there is nothing that says that because the building is being occupied illegally, that the inspector writes that in such a way that the building needs to be vacated. So we need to be clear about that as well. There are often times where violations are written in lieu of a vacate order. If the building is deemed to be safe or habitable, because of there'll be a separation between what is a zoning infraction and what is a safety and life-threatening situation. So there is nothing that says that the Department of Buildings will go out there, even with that referral from the loft board and vacate.
Then I don't understand why it's a big deal. If you're saying on the one hand that everybody already knows, and you're saying on the other hand that maybe nothing will happen, but on the third hand you're saying that we shouldn't say it.
I think what he was saying on his first hand was that DOB is already on notice.
I understand, but there's, maybe all of a sudden DOB is superhuman and is able to manage, hundreds of thousands of buildings and is monitoring them carefully every single second. This is just our tiny little sliver of New York City that we're responsible for. And I just want to make sure that nothing gets, when we're done with it, whether it's done because it went through the program or because it didn't go through the program, we're done.
Just a quick question. There was some case you mentioned when you do a direct referral to within the buildings department. What are the circumstances for that?
I'll give you an example of something that happened this past few weeks. I received an anonymous letter from a group of tenants in Brooklyn. They were not necessarily tenants in one of our buildings. They were reporting on a building that had an application pending. And what they were telling us was that there was all kinds of unsafe activity going on in the building, on the roof of the building, all over the building. Once I'm notified of that, I have to send that upstairs. I'm downstairs on the third floor. Upstairs is the people that do this type of thing, and the enforcement people. So I gave it to Mr. Ranchty, I gave it to Tim Hogan, so that they could follow up. When I received information about another building in Brooklyn, where the tenants were, and this was a building in our jurisdiction, where the tenants were being terrorized, I sent that upstairs. When I got a letter from an attorney in a different building saying that the building was unsafe and citing to me specifics, and this was a building in our jurisdiction, I did something that I almost never do, and that is that I asked DOB to send out inspectors. Because if you tell me that the building is unsafe and there are fire hazards, I'm going to go to DOB and say, please go and inspect. So those are the types of situations where I will go and contact DOB. We have a rule in the statute. It says that we can call upon the different city agencies to help us for whatever reasons we deem. We can call the fire department, which we have. That's why we have Chief Spatafora here. I do go upstairs and discuss these things with the people in enforcement. Before the loft board before the loft law was expanded, I recall that they went to a building in Brooklyn. It was definitely a fire hazard. They decided, working with the community people, not to vacate the building. Instead, they put fire marshals in. There are all kinds of different ways. I mean, it was definitely an illegal occupancy. And they chose not to vacate. The advocates for the community attempted to have them be able to stay. I believe that now the building is in our jurisdiction. So those are the types of incidences that have happened. One with the building that's pending, and most of them with buildings that are in our jurisdiction.
Yes, Mr. Mayor.
Look, there's a very narrow issue before us. A narrow issue before us, since we know we're not responsible for buildings which should be IMDs, where applications should be made. We have no ability to force them.
Correct.
So therefore, the issue is, once you stop, can you not withdraw? Very, very discrete issue. Once you start, you're in our jurisdiction, and you can't withdraw. Or we have to approve withdrawal. So the question is, do we seek guidance from court counsel on this? Do we know, we could have raised it to the ALJ. We could have asked her to determine it. Did she approve the stipulation? I didn't bring the backup materials. Did she approve the stipulation of settlement, or did she just allow the case to be withdrawn?
No, it's the stipulation of settlement is on oath letterhead. It was cobbled together by our hearing officer, and that, to me, the real test for this case would be for us to instruct oath and say there are deals you can't make. If somebody applies for coverage, then your choice is to either find it covered or find it not covered, as opposed to allowing the tenants to write their own flavor of the law.
Well, this gets very nuanced. They could withdraw, and as not part of the process, enter into their own agreement. They made a mistake, because once they had the oath judge approve the stip, it was within their jurisdiction. But Lonnie, do you think we could get guidance on this, or do you want to wait for some court to decide in the other case?
Okay, this is just the caption, Mr. Delaney. This is not cobbled together by the oath judge. I believe that it was cobbled together by the attorneys representing both the tenants and the landlord. That would be Mark Sandercock for the tenants, a very able attorney who, by the way, used to work for the Loft board, and Jerry Profreet, who I believe used to be a member of the board. So this agreement is not, that I can see, so ordered by the court. Again, what you're saying is that either the court finds coverage and orders the units, the building to be registered, or it finds that it's not covered, and therefore the tenants have to leave. Although the tenants could then go and have a side agreement with the owner, or they could withdraw and never give us any reason, which they often do. And what you're doing is you're creating a situation whereby the court is not sort of overseeing the fairness of the stipulation, and that's fine. I mean, this is between the parties. This is enforceable by the attorneys, by the parties. Once it is withdrawn, it is no longer within our jurisdiction. We have no legal recourse at all. Now, what do we do with those buildings where we have 4 units that are IMD units and 7 units that are residentially occupied that are not IMD units? What do we do with those, Mr. Delaney?
I'm sorry, I don't understand. The
Well, there you
question.
you have people who are living in a building that are in residentially illegally occupying a unit in a building.
Why are they illegally, I'm sorry, I don't understand the
Well, you
relevancy,
have-
but
you-
if
well, I
you
mean,
want
but
to
we're talking-
pursue it, I'm happy to.
Well, you know,
Are they
need to
illegally,
challenge
are
it.
they illegally occupying it because they weren't part of the application? Are they illegally occupying because they moved in after the window period?
That's
I
right,
don't-
there are all
I don't
kinds of
understand
reasons
your-
why there are people living in a building who are not IMD tenants, nor are they certified artists, and they are not under the loft law. Their units don't get legalized, their units don't get brought up to code. You know, there are all kinds of different scenarios. I mean, Mr. Barrett was just talking about it before, about all of the buildings that have not come into our jurisdiction. Unfortunately, many of these buildings will not now be able to come into our jurisdiction. What do we do with all of those buildings?
I'm not cut this off a little bit. I don't think that we can start to suppose every possible scenario out there. We do have the cases before us. At this point, I think I'll entertain a motion to accept the summary cases. Michelle, thank you in a second. Second to accept the case.
Maybe we should table this one particular case.
Table it, pending one.
Pending, let's say, clarification from the law department, something, I really don't know, because there doesn't seem to be an answer to this. I mean, the only answer would be is if somehow some subsequent law would allow these buildings that can cure whatever possible hazard they are and to come under the broader jurisdiction.
First of
I mean,
all,
that's the only way I can see that we have any way out. Otherwise, whether we pass this or reject it or not, people are going to go on living there.
we could separate 4, 5, and 6 out, and we could vote on those. And let's do that. Let's not hold those hostage for the other case. And then I suggest that that you decide whether you want to have a vote on it. If you all feel strongly, then vote no. And we won't accept it, and we'll remand it back to oath. Or we'll send it back to us, or we'll table it again. That's up to you.
Okay. I think that we will vote on 4, 5, and 6 as a group on the summary calendar. So can I have a motion to accept cases 4, 5, and 6 on the summary calendar? Mr. Foggy, thank you. In a second. Mr. Delaney, thank you. Mr. Rivera, please call the board.
Mr. Bauer,
Yes.
Mr. Mayor,
Yes.
Chief Restoro,
Yes.
Chairman Shanti,
Yes.
Mr. Delaney,
Yes.
Ms. Bolden Rivera,
Yes.
Mr. Pagan,
Yes.
Mr. Schechter,
Yes.
Ms. Shelton.
Yes.
7 favors.
No,
No.
9 in favor.
Oh, 9 favors, sorry, 9 favors.
Thank you, Mr. Rivera. And at this point, so on the merits of case 3 on the summary calendar alone, I'd like to entertain a motion from the board to accept case 3 on the summary calendar.
Mr. Falcon.
Mr. Fargan, thank you. In a second? Ms. Schott, thank you. Mr. Rivera, call the board.
Mr. Barrett,
No.
Mr. Mayor,
Abstain.
Chief Spadafore,
Yes.
Chairman Shanti,
Yes.
Ms. Delaney,
No.
Ms. Bolden Rivera,
No.
Mr. Pagan,
So abstain.
Mr. Schechter,
No.
Ms. Shelton.
Yes.
Okay, I'll tell you what it is. It's 3 in favor, 4 against, no, 1, no, it's 2 abstain. It's 2 abstain, it's,
Want to do it again?
Spatafora is yes, Chief Spatafora. Ms. Sheldon is yes, and Mr. Renchty is yes.
What was the other one, yes?
Okay, and 1, 2, 3, 4 no, and 2 abstain.
Who were the abstentions?
Mr. Mayor and
Foggin.
Mr. Foggin. Okay, that's 79, that's 9. Okay, thank you.
And finally, the master case.
Okay, really?
Ms. Alexander.
This is case, where's my, this is Mario Vasquez, 388 Broadway, TR 1058. On November, no, that's wrong, and that's wrong. On January 17th, 2013, the occupant of Unit 4E in 388 Broadway, New York, filed an application seeking a finding that he is the protected occupant of the unit. In his application, the tenant asserts that he is entitled to protected occupant status because he has been the sole occupant of the unit since 2002, and the registered occupant of the unit, Elizabeth Salloway, is an illusory tenant. The record shows that Ms. Salloway informed the tenant that she planned to resume occupancy of the unit and she wanted him to vacate. When he failed to leave, Ms. Salloway initiated eviction proceedings against him in housing court. In his answer in the eviction proceeding, the tenant alleged that Ms. Salloway is an illusory tenant and thus he is the protected occupant of the unit. In a decision dated June 24, 2013, the housing court found that Ms. Salloway was not an illusory tenant and awarded her a final judgment of possession of the unit. After being granted to leave to do so, on October 28, 2013, tenant re-argued the merits of the case. A decision on the motion is pending. In this case, Ms. Salloway, the owner moved to dismiss the application, claiming that the protected occupancy status claim, having been fully litigated and decided by the housing court, was barred by the doctrines of res judicata and/or collateral estoppel. In her report, Judge Addison recommended the coverage application be dismissed based on the court's decision that Ms. Salloway is not an illusory tenant. The Loft Board has dismissed applications on collateral estoppel grounds where a court of concurrent jurisdiction decided the issue in dispute. In D. Francesco, the Loft Board held the tenant to be collaterally estopped from claiming Loft Board coverage because the tenant had unsuccessfully litigated the identical claim in a prior civil court proceeding. Similarly, in the matter of Garland Realty Corp., the Loft Board dismissed an owner's application contesting law coverage because the issue was previously decided. The tenant's claim for protected occupant status is based on the same defense that he raised unsuccessfully in the holdover proceeding. The staff recommends that the application be dismissed. However, as there has been no decision on the tenant's motion to re-argue, the staff recommends that the dismissal be without prejudice.
Questions or comments about the case? I have a motion to accept the case. Mr. Foggin, thank you. Ms. Second. Ms. Sheldon, thank you. Ms. Farrer, please call the board.
Mr. Barrett?
Yes.
Mr. Mayor?
Yes.
Chief Sparafora?
Yes.
Chairman Clancy?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
Mr. Foggin?
Yes.
Mr. Baxter?
Yes.
Ms. Sheldon?
Yes.
9 in favor.
Okay, thank you, Ms. Rivera. That is the agenda for our meeting. Any further questions or comments before we go?
We have no votes.
Attendance forms?
The attendance forms that you put past me?
Okay. This will conclude our April 24th, 2014. Yes.
I'm sorry, what are we going to do with that number 3 case?
That's why some of us abstain.
Well, the fact is that the motion lost.
We're going to have to send it back to him.
With any sort of instruction?
Yes.
What does that mean, sending it back there?
Well, they're back at square one.
How's it, the outcome going to be any different?
what happened in one of the other cases was that it went back to Oath, and the owner and the tenants, the tenants withdrew with no settlement. The other alternative is that we will, it's been defeated, and we will send it back to Oath. We will notify the parties, and if they so choose, they can either move for reconsideration or they can file an Article 78. I would imagine that, you know, I don't even know what they'll do. But those are the alternatives that they have. I mean, if we don't accept the settlement, then they're back at square one.
Okay, thank you all, and our next meeting will be here at Spector Hall, 22 Beach Street, May 15, 2014 at 2 p.m. Thank you.